Choosing a life partner is an integral part of choosing one's course of life. Some people regard this as the most important decision of their life. Good evening, one and all present here. We are the members of Group 5 and we are here to present the case of Supriyo Chakraborty and Anr versus Union of India. It is the landmark case of legal recognition for same-sex marriages in the country. In this case, two people, Supriyo and Abhay, of ages 22 and 25, met in Hyderabad.
Hi, I'm Abhay.
Gradually, they developed feelings for each other and fell in love.
I love you. Do you want to marry me?
Yes, I do.
They somehow convinced their parents for the marriage.
Papa, this is Abhay, and I'm love with him. I want to marry him. Can you do that? Yes, Papa.
Mommy, he is Supriyo and I want to marry her. लड़के से? Yes, because I love him and I think that he is the one for me. तुम लोग तो दोस्त थे ना? हाँ, but आप मेरी प्रायोरिटीज तो जानती है ना? But the society will not accept your relationship. कुछ तो लोग कहेंगे, लोगों का काम है कहना. Okay.
Thank you, Papa.
Very good.
While the preparations were in full swing, they got to know that they could not get married because there is no such law in the country that legalizes same-sex marriages. Now they approach the court of law.
Yeah,
Yeah,
for justice.
A short brief of the case before it actually begins. The petitioners, consisting of couples, individuals from sexual and gender minority communities, requested the Supreme Court to recognize the marriages between any two people, regardless of sexual orientation and gender identity. Under the marriage laws, namely Special Marriage Act 1954, Hindu Marriage Act 1955, and Foreign Marriage Act 1969, and to declare the notice and objection provisions of the Special Marriage Act and the Foreign Marriage Act as void by enforcing the fundamental rights guaranteed under Article 14, 15, 19, and 21 of the Constitution. The respondent, the Union government, opposed the request, including the extension of the right to establish a family to sexual and gender minority individuals in India, arguing that non-recognition of the rights of sexual and gender minority individuals to marry and establish a family does not violate the fundamental rights guaranteed under Article 14, 15, 19, and 21. The five-judge Supreme Court bench will now assemble to pronounce verdict on the pleas seeking legal validation for same-sex marriages. The five judges are Honorable Justice Hima Kohli, Honorable Justice SK Kaul, Honorable Chief Justice Chandrachud, Honorable Justice S Ravindra Bhat, and Honorable Justice PS Narasimha. Moving further, I would like to hand over the mic to my friend, who is the petitioner.
Your Honor, I am on the behalf of the respondent and my submissions on the behalf of the respondent are: My Lord, the Special Marriage Act is a species of general marriage laws. Marriage is conceived to be union between heterosexual across all laws on marriage, and procreation is an essential aspect of marriage. Your Honor, Article 19 and 21 of the Constitution guarantee all the persons right to marry a person of their choice, including LGBTQ persons. The Special Marriage Act violates the right to dignity and decisional autonomy of LGBTQ persons and therefore violates Article 21. Excluding LGBTQ persons from the Special Marriage Act discriminates against them on the basis of their sexual orientation and the sex of their partner. This violates Article 15 of the Constitution. Your Honor, the Special Marriage Act is violative of Article 14 of the Constitution because it denies LGBTQ persons equal protection of laws, non-recognition of same-sex and gender non-conforming marriage causes prejudice to the LGBTQ persons and denies them rights under social welfare and beneficial legislations. Your Honor, procreation is not the sole purpose of marriage. Marriage is not merely the meeting of two individuals, but much more. It is the union of two souls. The right to intimate associations is protected by Article 19, Clause 1, Subclause C of the Constitution. Your Honor, Article 21 of the right to form a family and the right of a meaningful family for all persons, including LGBTQ persons. The law defines family and households broadly and is not limited to a biological man and woman and their children. Surrogacy and adoption are available only to married couples, thus denying LGBTQ persons the right to form a family.
Does anyone have a fundamental right to marry?
Your Lordship made it as a part of life itself.
Okay.
Therefore, Your Honor, I pray that this Honorable Court may be pleased to issue a writ of mandamus or any other appropriate writ by declaring that the Special Marriage Act 1954 ought to apply to a marriage between two persons, regardless of their gender, identity, and sexual orientation, or in the alternative, or by declaring that the Special Marriage Act 1954 is unconstitutional and violative of Articles 14, 15, 19, and 21 of the Constitution of India insofar as it does not provide for solemnization of marriage between a same-sex couple and, Your Honor, may be pleased to pass any other writ, order or direction that this Honorable Court may deem fit and necessary in the interest of justice. I am obliged, my lord, and I would like to hand over the mic to my co-counsel to present the respondent side.
Your Honor, I am on the behalf of the respondent, and my submissions on the behalf of the respondent are: the Special Marriage Act is a species of the general marriage laws. Marriage is conceived to be a union between heterosexuals across all laws on marriage, and procreation is an essential aspect of marriage. It is up to the Parliament to enact a special code regulating non-heterosexual unions and the specific issues that such unions would face during and after the partnerships, after comprehensively engaging with all the stakeholders. The Constitution does not recognize the right to marry. An expression of person's sexuality is protected under Article 19, Clause 1, Subclause A of the Constitution. However, marriage cannot be traced to the right to freedom of expression or right to form unions under Article 90, Clause 1, Subclause C. In non-heterosexual unions, the child born out of surrogacy or artificial reproduction technology or adopted by the couples would feel the absence of either a father or a mother. The Special Marriage Act would become unworkable if it is read in a gender-neutral manner. It would also amount to this code redrafting many provisions, such as Section 2, Clause B, read with first schedule, prescribes a distinctive degree of prohibited relationships for the bride and the groom. According to Section 4, Clause C, the male must have completed 21 years of age and the female must have completed 18 years of age at the time of the marriage.
How is Section 4 Clause C involved here, and why is age factor to be redrafted?
Reading the phrase spouse in the place of male and female would render the distinctive minimum age requirement for marriage based on gender. If you are satisfied, my lord, I would like to move further.
Permission granted.
Much obliged, my lord. Further, the form of statutory oath which the parties are required to take for the solemnization of their marriage expressly uses the phrase wife and husband. According to Section 21, the rule of succession provided in the Indian Succession Act 1925 governs the succession of the property of any person who is married under the Special Marriage Act. The Indian Succession Act prescribes different rules and procedures for succession based on gender. The Supreme Court affirmed that marriage is a legal union of a man and a woman in the ruling of Mr. X versus Hospital Z and Rima Agarwal versus Anupam. To conclude with your honor, denying the right for sexual and gender minority individuals in India does not violate the fundamental rights guaranteed under Article 14, 15, 19, 21 and 25 of the Indian Constitution. In Navteej Singh Johar versus Union of India, the Supreme Court decriminalized homosexual conduct but did not legitimize it.
Thank you, Your Honor. There were 4 judgments, one each by Honorable Justice S Ravindra Bhat, Honorable Chief Justice D.Y. Chandrachud, Honorable Justice SK Kaul, and Honorable Justice PS Narasimha.
This court has recognized that marriage is a social institution. Marriage as an institution precedes the state. This implies that marriage structure exists regardless of the state. Terms of marriage are independent of the state and its sources are external. A gender-neutral interpretation of Special Marriage Act may not be equitable at times, and can result in women being exposed to vulnerabilities in an unintended manner. If Section 4 of Special Marriage Act is to be read in gender-neutral manner, the interplay of other provisions will lead to anomalous results, rendering the Special Marriage Act unworkable.
There were some agreements and some disagreements. Doctrine of separation of power can't stand in the way of this court to issue a writ to protect fundamental rights. Court cannot make law but can interpret and give effect to it. Then the subject of cureness is not urban or elite. People may be cured regardless whether they are from village or cities. Not only can an English speaking man lay claim to being cured, it's also a woman working at a farm in a rural area. Choosing a life partner is an integrated part of a life and what defines their own identity. The ability to choose a partner goes to the root of right to life and liberty under Article 21 of the Constitution. I disagree with Justice S Ravindra Bhat on certain aspects. Contrary to the Justice Bhat judgment, direction in my judgment do not result in the creation of an institution, rather they give effect to the fundamental right. The union government, state government and union territories are directed to ensure that pure community is not discriminated against. There is no discrimination in access to goods and services. Sanitize the bus of the public about the pure rights. Create a hotline for pure community. Create safe house for pure couples. Ensure intersex children are not forced to undergo operations. And also no person shall be forced to undergo any hormonal therapy. There shall be no harassment to pure community by summoning them to police station to inquire about their sexual identity. Police should not force pure person to return to their rental family. Police station Police should conduct a primary inquiry about the registration and FIR against the pure couples over their relationships. Supreme Court cannot strike down the Special Marriage Act or read words into the Special Marriage Act due to the institutional limitation. The court cannot read words in allied laws like Succession Act as it would be a legislation. And also I declare that failure of the state to recognize a bucket of the rights following from the pure relationships amount to the discrimination. Right to the enter into the union cannot be restricted on the basis of the sexual orientation. Transgender person and heterosexual relationship have the right to marry under the existing law, including personal laws. The unmarried couples, including pure couples, can jointly adopt a child. The union government, state government, and union territories shall not discriminate against the right to the pure community to enter into a union. Recording the statement of the Solicitor General Tushar Mehta, the Centre will constitute a committee to decide the right and entitlement of a person in pure union. I direct that the committee shall consider the following, including pure couples as family in ration card and willing pure couples to nominate for joint bank account, right flows from pension, gratuity, etc.
Same-sex relationships have been recognized from antiquity, not just for sexual activities, but as relationships for emotional fulfillment. Refers to certain Sufi traditions. I agree with the CGI, says the state must ensure that queer couples face no discrimination in accessing basic needs and societal tolerance. Giving right of marriage to queer couple by court was not possible as it is a legislative exercise.
In addressing the intricate constitutional questions surrounding LGBTQ rights and marriage, I emphasize the absence of binding precedent on the right to marriage for LGBTQ couples, as this specific matter has not been previously considered by the courts. LGBTQ individuals already possess recognized rights, including those related to gender identity, sexual orientation, and partner choices, which must be safeguarded from the threat or coercion. I concur that the marriage is not an unqualified constitutional right, but rather a product of legal or customary practice with the state obligation to protect these rights. I reject the challenge against the Special Marriage Act 1954 and the Foreign Marriage Act 1969. In line with the Justice Bhatt's reasoning, on gender construction. I also concur with the constitutionality of Regulation 5 Clause 3 of the Child Adoption Resource Regulation 2020. Marriage is a multifaceted social institution deeply rooted in culture, religion, custom and laws, taking on diverse form across communities. Therefore, there cannot be a single guaranteeing unrestricted entry and exit from this institution. I oppose the creation of constitutional rights to a union or cohabitational relationship resembling marriage, suggesting that legislative and executive process are better suited to address these issues.
Consequently, I dispose of the writ petition, emphasizing the role of the legislature and executive in shaping these matters.
The CGI has left it to the Parliament to decide whether same-sex marriages should be given a legal status or not. A hope to disappointment, India's legal LGBT community feels that this decision is a letdown for them. However, at the same time, the CGI said that the queer persons have an equal right to form a union. He further recommended that the government should take measures to prevent discrimination against LGBTQ individuals. Consequently, a total of 4 judgments were delivered with a degree of agreement and a degree of disagreement.